Carla Bean. She's an assistant district attorney with the DA's office. And we're going to talk a little bit about protective orders, stay-away orders, emergency protective orders, and she is our specialist. So welcome, Ms. Bean.
Thank you, Judge.
I would like for you to outline for our community, for those who might not know, what is the difference between those three types of orders?
Okay. I will start first with the what I call a final protective order. It is a court order that is filed by a victim of domestic violence against a perpetrator that prohibits the perpetrator from engaging in certain acts. Typically the acts are domestic violence acts. The final protective order can be anywhere from 2 years up to lifetime, and the applicant actually applies for that in person in the district attorney's office.
Okay.
The emergency protective order is an order where the victim can also get a protective order with the same prohibited acts. However, for the emergency protective order, the victim does not have to request it. It is granted when a perpetrator of domestic violence is in jail for domestic violence. The emergency protective order has to be signed and granted at the time that the perpetrator is in jail before release.
Is this a type of order that someone else can get on her behalf?
An assistant district attorney, a police officer, or the magistrate on his or her own motion can file for it.
Okay.
So, yes.
So the final protective order that you were just talking about, you said that a victim can come up to the DA's office and file for it for himself or himself, correct?
Yes, that's correct.
Where would they go?
A victim would come to, or an applicant, right, would come to the 10th floor of the district attorney's office, and he or she does not have to have an appointment, and they come to the window and say words that indicate that they want help.
Okay. Before we move on to the third type of order, are there certain things that the victim needs to be prepared to provide when they're filling out for a protective order?
Yes, ordinarily we tell victims to, first of all, bring some kind of identification. Oftentimes victims don't have identification because they fled. And so in the event they don't have an ID or a driver's license, we kind of pull it up and identify them from the DL that we can pull up, because that often happens. They also, if there are any pictures that they have, or any text messages, or any evidence of allegations of violence, then we ask them to bring that.
Okay, good. All right, so moving on to the third order.
The no contact order is actually an order that is made a condition of bond conditions. So for a no contact order, there typically is already some criminal charge filing. There is a case. And the complaining witness, as we often call them, the victim can ask the district attorney's office or the judge to do a no contact order. However, I think the big difference between the protective orders and the no contact order is that the no contact order can prohibit any type of contact, be it physical or any communications. However, the no contact order is ordinarily enforced by the judge.
Okay. So if a complaining witness decides they no longer want the no contact order, can they just get rid of it?
Ordinarily not, since the judge is the person who actually granted it. Typically the judges want there to be some kind of presence or some direct request to the judge that it be lifted.
So really it's a judge's order and the victim really doesn't have any say-so.
I would agree with that.
Okay. Now,
yes.
what are some of the consequences if an offender violates that stay-away order, the no contact order?
The judge, of course, can impose numerous types of conditions, or penalties rather. The judge can revoke the bond and put the perpetrator back in jail, can request that there be no bond at all, and also can impose electronic monitoring, as an enhanced manner of monitoring.
So if we have a violation of the protective order, what kind of consequences come out of that?
The violation of protective orders can and do result in an arrest by the police department. So the perpetrator will go to jail for violating the protective order.
So that's a whole nother case.
That's a whole new case, Judge, absolutely.
And in that new case of violation of protective order, there's probably going to be a stay away order out of that case.
Yes, absolutely, absolutely. Just keep enhancing the penalties for non-compliance.
So you could have an offender could have a protective order and a stay away order at the same time?
Absolutely, yes. And we often encourage all options, rather, just because the no contact order is, of course, judge enforceable. And so the protective order, if it happened at 3 o'clock, a.m. in the morning, of course, Judge, you may be on duty, but you probably won't be.
Probably
so
not.
The victim could call the police to enforce the protective order.
Okay. So if an offender keeps violating a protective order, are there any consequences for just keep getting new violation of protective order cases?
Yes. In fact, if there is a continuous violation of protective order within 12 months, irrespective of whether or not the first offense was reported, that can be a felony offense now. Because if a perpetrator is continuously violating a protective order, and let's say the victim first time didn't really call the police, but there was a second violation within a 12-month period, that offense is a felony offense.
Wow. So you go from a misdemeanor straight up to a felony.
Straight to a felony, absolutely.
Okay, y'all hear that?
Exactly.
Is there anything, that's a lot of good information, is there anything that you would like to advise or just, I guess, educate the community about in regards to any of those orders?
I would like to say something I think is very important about protective orders. In the district attorney's office, they are FREE free. You do not have to pay any money to apply for a protective order, and I think nowadays you typically have to pay money for anything that you get, and we have to pay for parking, so that's why I say that in this system. And so protective orders are free of charge. The filing of them, the service of them are free of charge to the community who comes, and also they can also go out to the community satellite offices. If they can't get here, because it's sometimes ominous finding parking, getting downtown, figuring out which streets are one-way streets or not. So we also have the satellite offices in the community where victims can go there to apply.
Oh, that's great. I completely forgot about that. All right, that's good information. You also can go to the DA's website. Is there information on there in regards to the satellite office?
Yes, they are. Yes, yes, it is, rather.
So if you go to the district attorney's website, you can find out any information. If you are a victim of domestic violence and are looking for some type of resource in regards to protective order or emergency protective orders or stay away orders, no contact orders. I know that's a lot of orders, but see their website for those satellite offices. Anything else?
I think that's all, Judge.
Thank you so much.
Well, thank you. It's my privilege.
All right.